I was in the school pickup line when my son's teacher ran out and told me not to let him get in the car with his father. I didn't understand why until I checked my phone. She was running. That was the first thing wrong. Mrs. Delacroix did not run. She was 62 years old, 28 years in the classroom, the kind of teacher who moved through school hallways with the unhurried authority of someone who had seen everything twice and stopped being surprised by any of it. But she was running across the Sycamore Elementary pickup lane in a cardigan and flat shoes, weaving between idling cars. One hand raised toward me like she was flagging down a cab on a busy street. I had my window down because the afternoon was warm, and I was listening to the radio and thinking about absolutely nothing. Oh, which is a luxury I would not have again for a very long time. She got to my car and grabbed the window frame with both hands and looked at me with an expression that had three things in it simultaneously: urgency, apology, and a careful, practiced calm that told me she was working hard not to let me see how frightened she actually was. She said, "Mrs. Achebe, Kofi cannot go with his father today." I said, "What?" She said, "Please pull forward and park. I need you to come inside." And then she looked past me, down the line of cars behind me, and whatever she saw there made her straighten up and turn her body slightly, putting herself between my car and the street. I should explain the situation as it existed before that afternoon, because the version of events that made sense to me in the pickup line was very different from the version that existed in reality. And understanding that gap is what this story is actually about. My name is Imani Achebe. I was 34 years old that October, a pediatric occupational therapist working 4 days a week at a rehabilitation clinic in the same suburb where my son Kofi attended second grade. Kofi was 7, small for his age, serious in the way that some children are serious, not unhappy, just precise. He preferred facts to stories and had opinions about breakfast cereal that he would defend at length. His father, my ex-husband Declan Voss, was 37, a regional sales manager for a construction supply company, and we had been divorced for 2 years. The divorce had been, by the standards of these things, relatively functional. No screaming, no lawyers fighting in hallways. A mediated agreement that gave Declan alternating weekends with Kofi, one weekday evening per week, and a holiday schedule we had sorted out over a shared Google document like two adults who had decided that hating each other was too expensive in time and energy. I had not loved Declan for the last 18 months of our marriage. I had also not been afraid of him. That distinction matters. What I had been, for reasons I could not have articulated clearly at the time, was vaguely uneasy. The kind of unease you dismiss because you can't point to anything specific, and because everyone around you is telling you that co-parenting is going well, and you should be grateful. The red flags, in retrospect, were not subtle. They were just individually dismissible, which is how red flags work. The first one I noted and then set aside was a conversation Kofi had with me in September, about a month before the pickup line incident. He had been in the bath, playing with a waterproof dinosaur set that he'd had since he was 4, and he said, without looking up from the dinosaurs, "Dad has a new friend who lives at his house sometimes." I said that was fine, that Dad was allowed to have friends. Kofi said the friend was a woman named Petra, and that she made dinner sometimes, and that she and Dad argued after Kofi went to bed. I said, still working hard to keep my voice conversational, that grown-ups argue sometimes, and it didn't mean anything was wrong. Kofi said, "She cried once." Then he went back to the dinosaurs, and I went back to pretending I wasn't deeply unsettled by what he had just told me. But I didn't say anything to Declan. We were co-parents. His personal life was not my business. I told myself this firmly enough that I almost believed it, and I moved on. The second flag was an email from Declan in late September, 3 weeks before the pickup line. It was about adjusting the Wednesday evening schedule, asking if he could swap his Wednesday for a Saturday the following month because he had a work commitment. The email itself was normal. What wasn't normal was the timestamp, 2:31 a.m. I had been receiving a lot of late-night emails from Declan in the past 2 months, not unusual in content, just unusual in timing, and the accumulation of them had created a low-grade background hum of concern that I kept turning down. When I pulled forward and parked and followed Mrs. Delacroix inside, Moshi took me not to her classroom but to the principal's office, where a woman I had never met was standing near the window. She introduced herself as Vanessa Okafor, a caseworker with the county's Child Protective Services Division, 9 years in the field. She was composed and direct, and she gestured for me to sit in one of the chairs in front of the principal's desk with the practiced ease of someone who had done this particular thing many times and understood that efficiency was a form of kindness. She said she needed to tell me some things, and she needed me to listen before I responded. I nodded. She told me that Kofi's school counselor had filed a mandatory reporter complaint 3 days earlier, following a disclosure Kofi had made during a routine check-in session. She said the complaint related to Declan. She said the details were sensitive and that she would share what she was legally able to at this stage. She looked at me steadily and said, Kofi told his counselor that his father had been driving under the influence on 2 occasions while Kofi was in the car. She paused. He also disclosed one incident that was more serious in nature, which is still being assessed. More serious in nature. 4 words that sat in my chest like something physical. I asked what that meant, and Vanessa said she couldn't share the specifics yet, but that CPS had made contact with Declan earlier that afternoon, and that he had become, in her careful language, uncooperative. That was when she told me they had attempted to reach me by phone for the past 3 hours, and I should check my missed calls. I had left my phone on silent during a 1 p.m., my patient session, and had not turned the sound back on before pickup. When I looked at the screen in Vanessa Okafor's presence, there were 11 missed calls, 4 from the CPS number, 2 from a number I didn't recognize, 3 from my sister Nika, whose text beneath the missed calls read, in order, call me, then Imani call me now, then a string of characters that were not words, and 1 from Declan at 2:47 p.m., 17 minutes before I had arrived at school, a voicemail I had not heard. I looked at Vanessa. She nodded. I pressed play. Declan's voice was wrong in a way I had never heard from him in 9 years of knowing the man. Too fast, too tight, with the specific compression of someone who is trying to sound controlled and is failing at it from the inside. He said he needed me to call him immediately. Oh, he said the situation was being mishandled, and there were things being said about him that were completely false. He said Kofi was confused and had misunderstood things. Then there was a pause, and his voice dropped into something quieter and harder that I did not recognize at all. He said, "Don't do anything until you talk to me." I set the phone down on the principal's desk and looked at Vanessa Okafor and said, "What do I need to do right now?" What I needed to do, according to Vanessa, was retrieve Kofi from the counselor's office where he had been kept after school under the guise of an art project, sign a temporary safety plan acknowledging that Kofi would remain in my custody pending the outcome of the CPS assessment, and then contact a family law attorney as soon as possible. She handed me a folder of documents. Point gave me her direct number written on a card and told me that the investigation would proceed on its own timeline and that my job was to be consistent, available, and to document everything. Everything. She used that word the way that people in her field use it, not as a suggestion, but as a technical instruction. I nodded. I went to get my son. Kofi was at a table in the counselor's room with construction paper and a glue stick, making something he described as a map of the solar system with extra planets he had invented. He looked up when I came in and said, "You're late." I said I knew and I was sorry. He gathered his things with the unhurried precision that was entirely his own, said goodbye to the counselor, a warm, careful woman named Brianna Osi, who had her master's in school counseling and had been at Sycamore for 4 years. Alms and walked out to the car holding my hand without asking any of the questions I was terrified he was going to ask. In the car, he asked if we could have pasta for dinner. I said yes. I drove us home with both hands on the wheel and my jaw clenched tight enough to ache. That night, after Kofi was asleep, I called my sister. Neka was 3 years older than me, a labor attorney in a different city, and the person in my life most likely to know what to do in a crisis while also being furious about it. She answered on the first ring, which meant she had been sitting with her phone. She said, "I talked to Declan's brother this afternoon. Declan called him after CPS made contact." I asked what Declan had said. Neka was quiet for a moment. Then she said, "He said you had put Kofi up to it." I felt my hand tighten on the phone. And I had not spoken to Kofi about Declan's behavior. I had not spoken to anyone at the school about Declan's behavior. Whatever Kofi had told his counselor, he had told her without any prompting from me, because I had not known there was anything to prompt. I told Neka this. She said she knew. She also said I needed a lawyer by morning. I called Constance, not the same Constance from another story, but my own, a woman named Renata Flood, a family law attorney with 16 years of practice and the specific quality of being unbothered by complexity. She specialized in high-conflict custody cases and had been referred to me by a colleague at the clinic who had used her 3 years prior and described her as someone who did not lose. I left her a voicemail at 10:45 p.m., and she called me back at 7:12 the following morning. Renata Flood was 48, methodical, and deeply unimpressed by Declan's voicemail when I played it for her. She said the phrase, "Don't do anything until you talk to me," directed at a custodial parent during an active CPS investigation, was itself a documentation opportunity, and she asked me to send her the recording immediately. She said we needed 3 things: a formal timeline of any concerning behaviors I had observed or been told about over the past year, copies of any communications with Declan that struck me as unusual, and a pediatrician's assessment of Kofi's current physical and emotional state, ideally within the week. She also said she was filing an emergency motion to suspend Declan's unsupervised parenting time pending the outcome of the CPS investigation. She was clear-eyed about what that meant. She said, "He will say you engineered this. That is predictable, and we will be prepared for it." She paused. "Was there anything at all, that you said or did that could be characterized as coaching Kofi?" I said no. She said, "Good, because I am going to ask you that question 4 more times over the course of this case, and the answer needs to stay the same." I told her it would. The CPS investigation moved at a pace that felt, from the inside, like standing still while something large and slow-moving bore down on you. Vanessa Okafor conducted her formal interviews over 2 weeks, including 2 sessions with Kofi using a forensic interview protocol at a child advocacy center, 1 session with me, 1 with Declan. From which she emerged, I learned later, having documented Declan's description of the allegations as completely fabricated by my ex-wife through the child. That phrase appeared in Vanessa's notes, which I eventually received as part of discovery. When I read it for the first time, I felt a cold, specific anger that I had not felt since the voicemail. Not because he had said it, but because I understood, reading it in Vanessa's careful official language, that he had planned to say it. That my ex-wife fabricated this was not a panicked response. It was a prepared one. Meanwhile, the 2 sessions with Kofi at the Advocacy Center were conducted by a forensic interviewer named Dr. Paulette Kamani, who held a PhD in developmental psychology and had conducted over 400 forensic interviews with children in the prior decade. She was not someone whose methodology could be dismissed easily. Her report, which Renata received before I did and described to me in a phone call, in which her voice was carefully neutral, documented Kofi's disclosures in detail. The driving incidents were confirmed. The more serious incident, which I now knew the nature of, involved Declan's new companion Petra being present during an argument that had turned physical in Kofi's presence. Kofi had used specific, unprompted language that Dr. Kamani noted in her report as consistent with direct observation rather than instruction. That phrase, consistent with direct observation, became one of the most important strings of words in the next 4 months of my life. Declan filed a counter-motion 2 weeks after Renata's emergency filing. It was what Renata had predicted almost word for word. He alleged that I had systematically influenced Kofi over a period of months, that I had a pattern of using the child as a communication tool, and that the allegations to CPS were part of a broader effort to eliminate his parenting time ahead of a custody modification I allegedly had been planning. He attached a declaration from his own mother, who stated that I had always been controlling and agenda-driven during the marriage, and a statement from a colleague who said he had observed me speaking negatively about Declan at a school event. The colleague was a man named Brett, whose wife was friends with Petra. And I want to be precise about that detail, because it matters. The person Declan found to corroborate his version of events was connected to the woman whose presence in his home Kofi had disclosed to the counselor. The conflict of interest was not invisible, and Renata saw it immediately. She filed a motion to strike the declaration based on the relationship and the lack of any specific incident or date in the statement. The judge, a family court jurist named the Honorable Marie Fenton, who had 18 years on the bench and a reputation for impatience with procedural theater, denied the motion to strike but noted in her ruling that the declaration's weight would be assessed in context. That was court language for, "I see what you're doing and I'm watching." The crisis peak arrived on a Thursday in November, 5 weeks into the investigation. Renata called me at 8:03 a.m. while I was driving Kofi to school. I pulled over around the corner from the building, let Kofi out, and watched him walk through the entrance, and then called her back. She said Declan had, the previous evening, filed an emergency motion of his own, alleging that Kofi had expressed a desire to see his father and that I was willfully preventing contact in violation of the existing custody agreement. He was also alleging that my work schedule made me an inconsistent primary caregiver and requesting an immediate custody evaluation. The evaluation request was standard legal maneuvering, but the emergency motion was not, and it had been assigned to Judge Fenton for a hearing in 72 hours. 72 hours. And I sat in my parked car on a residential street in November with the heat running and felt my body do the thing it had been doing for 5 weeks. the specific physical vocabulary of sustained stress, tightness across the upper back, a pressure behind my eyes, hands that didn't shake but didn't feel entirely mine. I asked Renata what we needed. She said we needed Kofi's pediatrician's most recent assessment, which we had. Dr. Amara Sule, pediatrician of 11 years, who had seen Kofi since he was 3 months old, and whose notes from his October appointment included observations about increased anxiety and a change in sleep patterns that she had documented with the kind of careful language a doctor uses when she suspects something and cannot yet prove it. We needed Dr. Kamani's full forensic report, which we had pending finalization. And we needed one more thing that we did not yet have, a clear, unambiguous piece of evidence that contradicted Declan's fabrication narrative directly, something that proved the timeline of disclosure had been organic, something the court could hold. That something arrived at 11:47 a.m. on the same day as Renata's call, in an email forwarded to her from Brianna Osei, Kofi's school counselor. Brianna had been reviewing her session notes in preparation for her own potential testimony and had found something she had overlooked in the initial review. A voice memo. Their sessions were audio recorded with parent permission as part of the school's documentation protocol, and Brianna kept the recordings on a secure school server. The memo from Kofi's September session, 6 weeks before the formal disclosure, 4 weeks before I had noticed anything was wrong, captured 11 minutes of a check-in conversation in which Kofi, entirely unprompted and in the middle of talking about a project about rivers, had said to Brianna, "My dad drives fast when he's tired and it scares me. Last time I had to put my seatbelt on myself because he forgot to check." Brianna had noted it and intended to follow up, but had been managing a caseload of 62 students, and the note had not risen to the level of a formal report at that stage. The voice memo, with its automated server timestamp of September 12th, was the clearest possible evidence that Kofi's disclosure was not recent, was not coached, and predated any involvement from me by nearly 2 months. Renata submitted it to the court as Exhibit C the following morning. She also submitted it to Vanessa Okafor, who incorporated it into the CPS report with a notation about its evidentiary significance. Then we went to the hearing. Judge Fenton's courtroom was the kind of room that felt deliberately unimpressive. Beige walls, fluorescent lighting, the low hum of a ventilation system that was never quite right. Declan sat at the respondent's table in a suit he had clearly bought recently. His attorney, a man named Gerald Park, who specialized in high-asset divorce and was somewhat out of his element in a child welfare proceeding. Renata and I sat at our table, and I kept my hands flat on the surface in front of me and looked at the judge when she spoke. The hearing lasted 2 hours and 14 minutes. Gerald Park presented Declan's emergency motion, citing parental alienation, thumb disruption of the child's routine, and my alleged use of Kofi as an instrument of the custody dispute. He was polished and structured and built his argument on the foundation that I had engineered Kofi's disclosures. Judge Fenton listened with an expression of total neutrality that I had been warned not to try to read. Renata responded. She submitted the voice memo. She submitted Dr. Sule's notes. She submitted the preliminary findings from Dr. Kamani's forensic report. She submitted Declan's 2:47 p.m. voicemail, time-stamped and transcribed, in which he had told me not to do anything before talking to him, while a CPS investigation into his conduct was actively underway. Judge Fenton looked at the voicemail transcript for a long time. Then she asked Gerald Park a question. She asked him to explain. In the context of his client's claim that the allegations were fabricated by the mother, how he accounted for a school counselor's audio recording from 6 weeks prior to the disclosure in which the child described concerning driving behavior independently and without any adult prompting. Gerald Park said he would need to review the recording. Judge Fenton said he had had the recording for 19 hours, having received the exhibit submission the previous morning. Gerald Park said his client had not been informed of this specific piece of evidence. Judge Fenton looked at him for a moment and then looked at her notes and issued her ruling. She denied Declan's emergency motion. She maintained the suspension of unsupervised parenting time pending the conclusion of the CPS investigation and the court-ordered custody evaluation, which she did order, but through a court-appointed evaluator of the court's choosing, rather than one proposed by Declan. She also issued a formal notation in the record regarding the voicemail, describing it as an attempt by the respondent to influence the petitioner's cooperation with an active child welfare investigation, and noting that it would factor into her ongoing assessment of parenting judgment. She was not done. She also ordered Declan to complete a substance use assessment within 30 days, referencing the driving disclosures, and to submit the results to both parties and the court. Declan sat very still through all of this. I watched his attorney make a note, and I watched Declan not look at me, And I thought about 9 years of knowing a person and the particular shock of discovering that you hadn't known all of them. The CPS investigation closed 6 weeks later. Vanessa Okafor's final report found the allegations of endangerment substantiated. Not alleged, not inconclusive, substantiated, which in the legal language of Child Protective Services means the evidence supported a finding that the child's safety had been compromised. The report was submitted to the family court and became part of the custody evaluation record. The substance use assessment Declan had been ordered to complete came back with findings that his own attorney described to Renata as problematic, a word that told me more than its clinical understatement was intended to. Declan entered a voluntary treatment program in January, which his attorney presented to the court as evidence of good faith. Judge Fenton acknowledged it as relevant and noted in the same breath that it also confirmed the underlying concern. The custody evaluation, conducted by a clinical psychologist named Dr. Owen Bridges, took 4 months and produced a 90-page report that recommended primary physical custody remain with me, with Declan's parenting time to resume in a supervised format after completion of treatment and a reassessment by Dr. Bridges at the 6-month mark. It was not a complete termination of Declan's parental rights. He was still Kofi's father. That would not change, and I was not asking for it to. What changed was the architecture of safety around my son. And that was what I had been asking for since the afternoon Mrs. Delacroix ran across the pickup lane in her cardigan and flat shoes and grabbed my window frame with both hands. There are things I want to say about how this experience changed me that go beyond the legal summary, because the legal summary is not the whole story. The legal summary is the skeleton. The rest of it is what it felt like to be a person walking through the weeks between that October afternoon and the final court order, which arrived by email in my work inbox on a Wednesday morning in March while I was between patient sessions. I cried in my car for 11 minutes and then went back inside and did my job. I think about the version of me who sat in the pickup line on a warm October afternoon, radio on, thinking about nothing. I don't miss her naivety, but I understand it. She was doing what most people do, giving the benefit of the doubt to someone she had chosen to trust, reading ambiguous signs charitably, on telling herself that unease wasn't evidence. What I know now that she didn't is that unease sometimes is evidence, that children report things accurately when they feel safe and when no one has told them what to say. That documentation done consistently over time becomes, in the right context, the difference between a judge who has questions and a judge who has answers. Brianna Osei's voice memo saved us. She had recorded it without knowing why she would need it, in a 30-minute session about rivers and geography, and a second grader's feelings about the week, and it had sat on a server for 6 weeks until the moment it became Exhibit C. I think about that a lot. 6 months after the final order, Kofi started supervised visits with Declan on Saturday mornings at a family visitation center in town. Then he came home from the first one and told me Declan had brought him a book about volcanoes, which was not quite right because Kofi's actual interest was seismology, not volcanoes, but it was close enough to show that Declan was trying. Kofi said, "Dad seemed nervous." I said that was probably okay, that new situations make people nervous sometimes. Kofi thought about this and then said he's sorry he made bad choices. I waited. Kofi opened the volcano book and looked at a diagram. I told him people can learn to make better ones, he said. Then he asked what was for dinner. I told him pasta. He nodded and went to wash his hands. 7 years old, serious in the way some children are serious, with a precision about him that I had spent years thinking was simply his temperament, and that I now understood was also, in part, meant his way of processing a world that had asked more of him than it should have. He was okay. He was going to be okay. That was the only thing that had ever actually mattered, and it was the thing I had been fighting for since a teacher in a cardigan ran toward my car on an October afternoon and said 3 words that changed everything. He cannot go.